Hello and welcome. For those that aren't aware, I'm Eloise Shelton, founder of Vanilla Recruitment. We specialise in recruiting office, accountancy, marketing and HR roles on a permanent and temporary basis. Today's employment law update for the HRHuddle is with Keeley Baigent of KSAB Law and is going to focus on the new carers leave rights that come into force on the 6th of April. So the session today is going to be recorded and I'll send it to you in the next week with Keeley's slides. Feel free to ask questions as we're going along and pop them in the chat box, which hopefully everybody knows where it is, and we will answer them as we're going along. I'll interrupt Keeley and ask questions. So I'm going to pass over to Keeley and I hope you enjoy your session.
Hello, everyone. And yes, as Eloise said, welcome to today's HRHuddle. So we're dealing with an employment law update today with a focus on the new carers leave rights that are coming into force on the 6th of April, along with associated rights, again, new rights or changes, in particular to the flexible working request procedure and right, and also touching upon the paternity leave changes too. So I'm going to share my slides and we'll commence the huddle. So jumping then straight into, or straight in with the question of why was the carers leave introduced and the changes to flexible working requests made. Back in 2020, a study was conducted by the CIPD and the University of Sheffield. And according to this, a quarter of working carers had considered giving up their job as they were unable to balance their career and their responsibilities at home. The study found many working carers were not being supported effectively by their employers and often felt they needed to reduce their working hours or refuse opportunities or take time off, and that impacted potentially on their career development. Of the 970 working carers surveyed for that particular study, 44% stated they were struggling to balance their work and their caring responsibilities. 28% of carers who worked full-time also provided at least 30 hours of care per week, equivalent to a second full-time job. And overall, this equated to 700,000 employees in England and Wales who combined full-time work with full-time care. More than a third, 36% surveyed, turned down a promotion or refused a job because of their caring commitments, while 30% had reduced their working hours. According to the survey, just 9% of carers said that their employer offered paid leave or any leave for caring responsibilities. And almost half, 46%, said that they had used their annual leave for that purpose, i.e. for caring for dependents. In 2020, another survey was conducted, and this time of 5,444 people across the UK, it was conducted by Ipsos. It reported that while men and women are equally likely to say that they have caring responsibilities, and the majority think gender shouldn't affect who cares, women are much more likely to be sole carers in joint caring situations. 6 in 10 women with caring responsibilities said they had not applied for a new job or promotion because of worries about how they would combine that role with their caring responsibilities. And 1 in 2 carers from a Black, Asian, mixed race or ethnically diverse background said the same thing. And then finally, the study said flexibility of all kinds, location, hours and more were commonly cited as the key thing employers could do better to support people who are juggling jobs of some kind while also looking after children or others with caring needs. Unsurprisingly, the report confirmed that caring responsibilities impacts employees' working days. 52% of women, compared with 42% of men, said their day job has been interrupted because something came up with the child or an adult that they cared for. When it came to asking about flexible working arrangements to support caring responsibilities, more than half of respondents said they would not feel comfortable. 43% still thought there was a stigma attached to working flexibly. More than one in three respondents believed flexible working blocks career progression, with fewer than 1 in 5 having asked their employer to work flexibly. Of those who had made formal requests, 80% though had had them accepted. Interestingly, employees on higher salaries tended to be granted the most flexibility, with 75% of those in £26,000 a year feeling supported to manage caring responsibilities. Only 50% of those earning less than that figure enjoyed the same freedom. Ipsos Chief Executive Kelly Beaver said a record number of women are in paid work in the UK, and they make up nearly 50% of the workforce, but our research shows that many feel they are held back in their careers by caring responsibilities which are not shared evenly. The majority of those we surveyed believed that more of this responsibility should be shared equally, irrespective of gender, and the employees have a key role in making flexibility at work the rule, not the exception. And so after much campaigning and these number of surveys, the government finally legislated the changes to flexible working rights, but also the carers leave right, which we'll come on to look at. So the carers leave right then, it comes into force on the 6th of April. After the Carers Leave Act 2023 received royal assent in December, and regulations were passed in Parliament on the 27th of February. According to the charity Carers UK, around 9% of people are providing unpaid care to a dependent, meaning a large proportion of the workforce could be affected. Helen Walker, Chief Executive of Carers UK, said, passing the regulations associated with the Carers Leave Act is a vital moment, setting in stone the process for working carers requesting carers leave from their employer. This brand new right will help many carers stay in work and support businesses to retain their staff too. So firstly then, what is the Carers Leave right? The new regulations provide that an employee who has a dependent with a long-term care need may take up to 1 week's unpaid leave to provide or arrange care in each rolling 12-month period. But what's the meaning of dependent and long-term care need? And this is the key to the provision. So a person is a dependent for the purposes of carers leave if they are a spouse, civil partner, child or parent of the employee, or they live in the same household as the employee, otherwise than by reason of being the employee's boarder, employee, lodger or tenant, or reasonably rely on the employee to provide or arrange care. A dependent has a long-term care need if they have an illness or injury, whether physical or mental, that requires or is likely to require care for more than 3 months, or they have a disability for the purposes of the Equality Act, or they require care for a reason connected with their old age. And as we know, a person will have a disability under the Equality Act if they have a physical or a mental impairment which has a substantial and long-term adverse effect on their ability to conduct day-to-day activities. What should be noted is that carers leave cannot be used to provide general childcare, and it's there really for, as it indicates, in respect of a child who has long-term health or disability-related care needs. So general childcare needs will be covered by the existing right, and in particular the right to take unpaid parental leave. So how may the leave be taken? The leave may be taken in either individual days or half days, up to a block of 1 week. A week means the length of time the employee normally works over 7 days. So if someone usually works 3 days a week, they can take 3 prorated days of carers leave in that year. This can be taken all at once, as half days or full days. The amount of leave does not increase if the employee has more than one dependent in need of care. It is still a maximum of 1 working week every 12 months. Is there a required period of notice? An employee who wishes to take carers leave will need to give notice. The required notice is either twice as many days as the period of leave required, or 3 days, whichever is the greater. Employees needing to take emergency time off may be better using that right, or the right to take off time for dependents. We call it an emergency leave right. Carers leave is designed to cover those planned times off to look after dependents. Can the employer waive the notice requirement if it wishes to do so? An employer can do, yes, they may waive the notice requirement where all the other requirements of the regulations have been satisfied or met. Does the notice need to be in writing? It doesn't. It's not prescribed in the legislation as being a requirement. However, it might be something that you wish to prescribe in your policies. Can the employer require proof to support the request? And this is an important one. Employers cannot ask for evidence relating to an employee's caring responsibilities or ask how the worker intends to use their leave. This is due to data protection issues around handling personal sensitive data. So how can we get around this? Because it may well be an issue for employers. You could try and take a positive approach and use a self-identify method. So, for example, including a questionnaire or questions relating to caring responsibilities in a general survey that you conduct for your staff. It's National Carers Week in June of this year, so that could be a good time to conduct such surveys so that you can then obtain evidence about your staff and workforce about any caring responsibilities that may have. Also, another option is to ask employees to complete a self-certification form declaring that they are a carer taking time off and making it clear in that form the definition of what caring responsibilities are, or giving examples. So it's a bit like a self-certification medical form, but it's just confirming that they are taking or exercising their right to take carers leave. And then, as I say, you can put those examples in the policy and with the form so that everyone's clear what the purpose of the leave is. Can the employer decline a request? An employer cannot decline a request altogether, but the employer could postpone the carers leave request if the following apply. So firstly, the employer reasonably considers that the operation of the business would be unduly disrupted if it allowed the leave during the requested period, and that's a reasonableness test. The employer allows the employee to take a period of carers leave of the same duration within a month of the period initially requested. So it's not that long, 1 month. And then thirdly, the employer gives the employee a written notice within 7 days of the initial request, setting out the reason for the postponement and the agreed dates on which the leave can be taken. And obviously, putting forward an alternative date, you are going to need to consult with the employee about that. So what are the employee's rights regarding pay and benefits during the period of carers leave? As with many of these statutory leavers' rights, an employee is entitled to the benefit of all their terms and conditions of employment during the leave period, apart from the right to remuneration. It is an unpaid right. They will also be subject to all their obligations under the employment contract, other than obviously attending work and conducting their work. Again, just like other forms of leave, employees can offer more than the statutory 1 week of leave, and they could offer to pay employees or elect to pay employees whilst taking some or all of the carers leave. That's down to the employer's discretion. Offering paid carers leave instead of the statutory unpaid carers leave, or providing a longer period of leave, can have some benefits. Some employers are doing it now, including reduced absence and reduced sickness absence as well. What if the employer already provides a contractual right for employees to take carers leave? Where there is a contractual right to take carers leave, an employee will only be permitted to take advantage of whichever right is more favourable. However, the employee will still benefit from the protection of the statutory scheme. What other options are available for carers? Because caring responsibilities ebb and flow depending on the range of health and personal factors, employees may want to draw on the different policies and different rights to support their needs in respect of their caring responsibilities. So managers could point employees who are carers to their flexible working policies and flexible working rights. And obviously they change in April, which we'll come on to in a moment. The organisation could consider offering compassionate leave or an extended period of unpaid annual leave if circumstances require it, and that could be bolted on to the end of unpaid carers leave or in front of it. Employees needing to take emergency time off will be better using time off for dependents. That right, again, it's an unpaid right, but it deals with dealing with an emergency situation. What should we include then in a carer's leave policy? What we need to do is get one in place in readiness for April. Once in place, we need to make sure, or when we're drafting it, we need to make sure it deals with a number of matters, including clear definitions of carers and dependents, whether the leave is paid or unpaid, how much leave an employee can take, how much notice they should give, examples of caring responsibilities, and that's going to be key. So it's very clear what our expectations are of employees if they are going to exercise their rights to take carers leave. And because we can't ask for evidence of that, it's more important than anything really to make sure that that list is in the policy. Information about support available via external organisations or resources, and information about other relevant rights or working arrangements such as flexible working. So this carers leave policy is going to link into the flexible working policy. In addition, as we said, you might want to create a form for employees to complete should they wish to take the leave, and that should refer to the policy too. What I'll do after the huddle is I'll send to Eloise a copy of a draft carers leave policy. So that might be the basis on which you want to start drafting your own if you haven't got them in place already or in readiness.
Thank you. That'd be fantastic. I'll put it on the Facebook group for everybody.
Yeah, brilliant. So what else do we need to do? So we need to draft our policies, get those in place, but it might be worth also doing a quick training session for line managers or those that are going to be dealing potentially with these issues or requests if they're line managing teams. We need to present them with the policy, talk to them about the requests that could be made further to it. We need to make sure managers don't ask what activities the leave will be used for or to evidence the caring needs. But as I've said, it might be prudent for the managers to be able to give examples of what the leave should be used for. They might be settling official matters such as pensions or legal documents, taking dependents to medical appointments, or dealing with care homes or social services. That's just to name a few, but there will be some listed in the policy. Some employers are starting to, and have done already, introduced a carer's passport, where an employee can share their responsibilities with their line manager via an editable document, and update the circumstances, or as I say, they can use that form if they are going to be requesting carer's leave. What will be the impact, do we think, of the new carer's leave provisions? Well, some commentators are saying, well, it's only a week. Surely employers can work around that, but it will hit small to medium-sized employers. We are dealing with an ageing population, and yes, more than ever, and we are grappling with both childcare issues and also elderly parents, ill parents, for example. So I think it is going to be impactful. It might be disruptive to some small to medium-sized employers in dealing with these requests and also facilitating them and ensuring that the work is covered. What protection then is offered to employees in respect of taking carer's leave? As with the other family-friendly rights, employees have the right, as we've said, to return to the same job, or first of all, the right to remain on the same terms and conditions, less obviously remuneration, but they've got a right to return to the same job after a period of carer's leave. What an employer can't do is say, if you go on carer's leave, we're going to actually distribute your workload to somebody else and demote you, which of course none of you would do, but that's what it's protecting against. Terms and conditions will remain unchanged. Also, as with the other types of statutory leave, an employee will be protected from detrimental treatment or dismissal because of them taking or stating that they wish to take carer's leave. If the employee does suffer detrimental treatment or is dismissed because they exercise their right to take carer's leave, or said they wish to take carer's leave, then they can bring a claim in the employment tribunal. If successful, they will be awarded compensation. If they bring a successful claim of detrimental treatment for exercising their rights, then they'll be awarded compensation, which the employment tribunal determines just and equitable. So that might be loss of earnings, or it might be some reflection of injury to feelings, what is just and equitable in the circumstances. If they are dismissed because of them exercising carer's leave, that dismissal will be automatically unfair, which means that they don't have to have a prescribed period of service in order to bring a claim for automatic unfair dismissal. And if they succeed on that, then they will be awarded a basic award, which is exactly the same as the statutory redundancy payment, and a compensatory award, which is loss of net earnings and benefits for a reasonable period. Compensatory award capped at 12 months gross pay, or currently 105,707, but increases to 115,115 on the 6th of April. Okay, so what other claims might an employee assert they have in connection with exercising their carer's leave rights? So there's not only the claims for detrimental treatment and or automatic unfair dismissal that might be pursued, but other claims might include those of discrimination. As I've said, and as those surveys and studies have indicated, the majority of carers in the UK are women, and therefore potentially claims could be brought not only for breach of an employer's obligations under the carer's leave rights, but also for sex discrimination. Discrimination claims also can be brought based on an employee's association with another person. So this means, their association with another person who has a protected characteristic. So the protected characteristic doesn't actually have to be that of the employee. It can be the protected characteristic of somebody else with whom the employee is associated. So the example being, the employee is treated less favourably because of their association with their elderly parent who they care for, or their elderly person dependent that they care for who also has a disability or has generally has a disability, so it doesn't have to be elderly. So if an employee is treated detrimentally or unfavourably because of their association with an elderly or disabled dependent who they are caring for, they could then pursue a claim of discrimination based on the dependent's protected characteristic of age or disability. So this is quite key in considering the protection that's afforded to carers in the workplace. An example of an old case on this subject is that of Coleman and Attridge Law. You've probably all heard of it. It's an old case now, but it does illustrate the point. The facts of the case are that Mrs. Coleman brought a claim in the Employment Tribunal alleging, among other things, that she had suffered direct discrimination by her former employer, Attridge Law. Mrs. Coleman was not disabled, but her son, for whom she was the primary carer, was accepted to be disabled for the purpose of the claim. The preliminary issue before the tribunal was whether Mrs. Coleman was entitled to bring a disability discrimination claim based on her association with her disabled son, rather than any disability of her own. The case went to appeal and a reference was made to the European Court of Justice. The Advocate General delivered his opinion that the legislation provided protection against direct discrimination and harassment to individuals who are associated with a disabled person. The European Court of Justice agreed and concluded that the legislation could be interpreted as prohibiting direct discrimination and harassment on grounds of disability in respect of a person who is not disabled, but is the primary carer of a disabled child or adult. The case was decided back in 2008, and so under the old Disability Discrimination Act. However, the position was confirmed to be that under the Equality Act. So what this means is that in relation to disability, the law provides protection for carers. And as I've said, the same can also be said in respect of the protected characteristic of age. In the age discrimination can also apply to carers who are discriminated against further to caring for an elderly dependent. Another case to note about associative discrimination is that of Follows and Nationwide Building Society. And in this case, an employment tribunal considered whether an employee who was caring for her disabled mother had been discriminated against. The background of the case concerns both direct and indirect discrimination. As we know, direct discrimination occurs when there is less favourable treatment because of a protected characteristic compared to other people. And as we've seen, direct discrimination does not require the less favourable treatment to be because of the protected characteristic of the victim. Direct discrimination can occur, as we've seen, where the reason for the less favourable treatment is the protected characteristic of someone with whom the victim associates themselves. So in this case, their dependent who they're caring for. In contrast, though, and at this time, indirect discrimination, it was believed, could only relate to the individual employee's protected characteristic. So indirect discrimination, we didn't believe, could be associative indirect discrimination in the same way as direct discrimination. But this is the point of the case. So indirect discrimination occurs where a provision, criterion or practice, which we refer to as a PCP, is applied to everybody, all employees. But what that provision, criterion or practice does is places a group of people who hold a particular characteristic at a particular disadvantage. And then they place the claimant at that particular disadvantage. So it's group disadvantage and it's individual disadvantage. And it was believed that that group disadvantage and individual disadvantage had to be the disadvantage of the individual claimant, so not somebody they associate with. However, the requirement for the claimant to have the protected characteristic isn't a requirement under the European legislation. And it was challenged in a case called Shez. In that case, the European Court of Justice held that the concept of associative discrimination could, in principle, be extended to indirect discrimination. And essentially, in that case, the European Court of Justice ruled that a person need not possess a protected characteristic in order to bring a claim for indirect discrimination. The court said it is sufficient for a person to show that they suffer a particular disadvantage alongside a disadvantaged group. And as a result, that case has major implications for indirect discrimination law in the UK, and in particular in relation to associative discrimination. So the facts of this case are that Mrs. Follows was employed by Nationwide Building Society as a senior lending manager, or SLM. She was employed from December 2011 until she was dismissed by reason of redundancy in January 2018. Throughout that time, she was employed on a home worker contract in which her principal place of work was home. The primary reason for working from home was because Mrs. Follows was the carer for her disabled mother. Nationwide's management was fully aware of the reason that Mrs. Follows needed to work from home and accepted that Mrs. Follows' mother was disabled for the purposes of the Equality Act. Although Mrs. Follows was employed on a home worker contract, she did attend the office 2 or 3 days a week. She had high ratings and appraisals throughout her employment, and in particular had a documented history of excellent supervision of individuals within the team. In October 2017, a decision was taken to reduce the number of SLMs from 12 to 8, and that all SLMs would need to be office-based. Nationwide's reasons for the role to be office-based were firstly, a greater need for staff supervision by SLMs due to a change in the nature of the work, and secondly, feedback from junior staff which suggested dissatisfaction with the level of supervision provided to them. This is something that we heard a lot about during COVID and after COVID, when employers were trying to get employees back into the workplace. Anyway, in this case, so as a result, Mrs. Follows' role was put at risk of redundancy and a consultation process began. There were more than enough volunteers for redundancy to meet the required reduction in SLM headcount. Mrs. Follows did not volunteer for redundancy as she wanted to stay in employment. Throughout the consultation process, she informed Nationwide of her wish to retain her existing arrangement of working from home and attending the office, which she believed was feasible going forwards. Despite this, Nationwide approached some of the volunteers for redundancy to request that they stay on. Mrs. Follows was not asked to stay on and was subsequently dismissed in January 2018. The reason given was redundancy. Mrs. Follows' colleague, Mr. Gregory, who was not disabled and was not a carer, was also employed on a home worker contract. He received essentially the same treatment as Mrs. Follows and was also dismissed. Mrs. Follows brought claims of unfair dismissal, direct and indirect associative discrimination on the grounds of disability, indirect sex discrimination, and indirect age discrimination. So what was the decision? The Employment Tribunal upheld the claims of unfair dismissal, indirect associative discrimination on the grounds of Mrs. Follows's mother's disability, and indirect sex discrimination. The claims of direct disability discrimination by association and indirect age discrimination failed. So the claim of direct associative discrimination on the grounds of disability failed. Now, this was because of Mr. Gregory. So Mr. Gregory was also employed on a home worker contract, but he wasn't disabled and he was not a carer of a dependent adult, or he wasn't a carer at all. But he received the same treatment as Mrs. Follows did and was also dismissed. So that then meant that the employer, or the employee in this case, Mrs. Follows, was unable to say she received less favourable treatment because of her association with her disabled mother or her caring responsibilities. Because Mr. Gregory, who didn't have those responsibilities, was also dismissed. That was her comparator. So her claim failed because of that. However, the tribunal upheld the claim of indirect disability discrimination by association. The tribunal first considered the issue of whether it had jurisdiction to determine a claim of associative indirect discrimination arising from the case of Shays. Nationwide argued, of course, that the case could not apply to an indirect associative discrimination claim, whereas Mrs. Follows argued the opposite. But the tribunal concluded that the legislation must be read in a manner consistent with the judgment in Shays, and as such, the definition of indirect discrimination must be read so as to apply to employees who are associated with a person with a relevant protected characteristic. So in the case, the provision or PCP that was being relied upon was the requirement that SLMs could no longer work at home on a full-time basis. The tribunal accepted that due to their care commitments, carers for disabled people are less likely to be able to satisfy that requirement or a requirement to be office-based than non-carers. And as such, the requirement to no longer work at home put Mrs. Follows at a substantial disadvantage because of her association with her mother's disability as her principal carer. As Nationwide had not discussed any alternatives, had not provided evidence on which the decision was based, and had ignored Mrs. Follows's view that the role could continue as per her existing arrangements, the tribunal held that Nationwide had not taken such steps as were reasonable to avoid the disadvantage that was being suffered by Mrs. Follows in applying the practice to her, or the requirement to her. In respect of the justification defence, so if an employer is found to have indirectly discriminated against an employee because of the application of a PCP, then the employer might be able to say that, or they might be able to justify the practice. They might be able to say, well, the practice is justified because it satisfies a legitimate aim. And in this case, this is what they said. They said the legitimate aim relied upon by Nationwide to defend the claim was a need to provide effective on-site managerial supervision and support to more junior staff following a reduction in SLM headcount and a change in the nature of Nationwide's lending business. But the tribunal held that the need for on-site supervision in itself contained a discriminatory element, and as such, it said that couldn't be run as a legitimate aim. Also, the tribunal concluded that selecting Mrs. Follows for redundancy and dismissing her was not a proportionate means of achieving any legitimate aim. The tribunal was not satisfied that the measure corresponded to a real need, nor was it based on actual evidence or rational judgment. Rather, it was based on Nationwide's subjective view following some dissatisfaction expressed by junior staff, together with management's view that the new arrangement would be better. Nationwide had also failed to take account both of Mrs. Follows's view that the role could be undertaken from home and her history of excellent supervision work. The tribunal concluded that there was no evidence that selecting Mrs. Follows for redundancy and dismissing her was a reasonably necessary way of achieving its aim of high standards of supervision. There were other non-discriminatory means of achieving that aim, including working from home and attending the office for 3 days a week, as Mrs. Follows had already been doing. As such, the claim of indirect disability discrimination by association was upheld. So it's a really quite interesting case because of, first of all, the carers' leave rights that come into force in April, but generally because of the more recent approaches of employers of trying to get employees back into the workplace after a long period of working from home due to COVID. And really, it's confirms that the 3-day or the hybrid working environment is okay, but a requirement to work full-time in the office may result in successful claims for associative discrimination for carers and potentially also sex discrimination in respect of females who are conducting childcare, have the bulk of childcare responsibilities. Moving on then to the new flexible working rights, which do link in with the carers' leave provision. So under the Employment Relations Flexible Working Act 2023, there will be extended flexible working rights, which come into force on the 6th of April, as we know. Will the qualifying conditions, will the qualifying continuous period of service change? So currently, employees with at least 26 weeks continuous employment can make a request for flexible working under the statutory scheme for any reason. From 6th of April, the right for an employee to make a flexible working request becomes a day one right. And the current requirement for an employee to have at least 26 weeks continuous employment will be removed. So this is the big change, and that qualifying period of service will be removed. Will there be any changes to how an employee should make a flexible working request? The employee triggers the statutory procedure by making a written request. Currently, to trigger the statutory procedure, an employee's flexible working request must, first of all, be in writing. It must be dated. It must state that it is an application made under the statutory procedure. It must specify the change that the employee is seeking and when they wish the change to take effect. Currently, it must explain what effect, if any, the employee thinks the change would have on the employer and how any such effect could be dealt with. And then finally, it must state whether the employee has previously made an application to the employer, and if so, when. So these requirements usually sit, well, they're the legislative requirements, but they usually sit in a flexible working policy. When the legislation comes into force on the 6th of April, the requirement for an employee to explain what effect, if any, they think their requested change will have on the employer and how any such effect could be dealt with will be removed. I don't know what your experiences are, but it's something that I've always grappled with in terms of advising clients before about that provision, because sometimes employees don't know and they don't know what to put put in that section about why they think it's going to affect, they'll just say, I don't think it has an effect. So it was a bit of a pointless provision anyway, but it's officially been removed, or will be removed, from the 6th of April. In place of this, though, it seems, the new ACAS draft code of practice suggests that employers should make the information that must be included in the statutory request for flexible working clear to their employees, and this could be done by a flexible working policy, which we've said, and which most employers will have. Will there be any changes to how an employer should deal with a flexible working request? So currently, an employer who receives a flexible working request under the statutory scheme must, first of all, deal with it in a reasonable manner. So that's the reasonable test. Secondly, notify the employee of its decision within the decision period, unless that decision period is extended by agreement. And then also the prescription is that an employer must only refuse a request on one or more of the permitted 8 grounds. Now, from the 6th of April, there will be a requirement that an employer must consult with an employee before refusing their application. Now, again, I would say that most employers, on receipt of a flexible working request, would have consulted with the employee about it anyway. But it is now a legislative requirement that consultation takes place. The new draft ACAS code suggests that the employer should invite the employee to a consultation meeting to discuss the request. The draft code also goes on to suggest that the employer should give the employee advance notice of the time and place of the meeting, and the meeting should be held without unreasonable delay, be held in private, either in person, remotely, or via online video conferencing, and be conducted by a person with sufficient authority to make a decision. The code suggests that it will usually be helpful to discuss the potential benefits or other impacts of accepting or rejecting the request, and any practical considerations involved in implementing the request. And if the original request cannot be accepted in full, the employer and employee should discuss if there's any possible way of securing some of the benefits that the original request sought. They could discuss, for example, any potential modifications to the original request, or any alternative flexible working options that may be available and suitable to both parties. It may also be helpful to discuss whether a trial period is appropriate to assess the feasibility of the arrangement. And I would always suggest a trial period if the parties are unsure if the arrangement could work. A written record of the meeting which provides an accurate reflection of the discussion should be kept. So that's the code requirements relating to the consultation prescription under the legislation. So is there any change then to the decision period? Yes. So an employer must notify the employee of its decision in respect of the employee's flexible working request, including the decision on any appeal within the decision period. Under current legislation, the decision period is either of the following: 3 months, beginning with the date on which the employee's request is made, or such longer period as the parties agree. The change will be that the decision period will be reduced from 3 months to 2 months, so shortening that period of time. In assessing when the decision period starts, we need to take into account of the following. So it runs from the day that the employer receives the request, taking into account that where the employer agrees that the request can be made electronically, then it's when the email request is received. If a request is sent by post, it's received on the day that it would have been delivered in the ordinary course of post. An agreement to extend the decision period in any particular case may be made. And it has to be made either before the original decision period expires or with retrospective effect within 3 months, beginning with the day after that on which the original decision period came to an end. There is no requirement in the legislation for the agreement to extend the decision period to be recorded in writing, but of course I would always recommend that, and it's good practice to do so. And an extension of the decision period needs to be addressed directly and agreed by the parties. We'll come on to have a look at briefly in a minute, but it is extremely important that you deal with a request within the decision period. So if you are going to run out of time in dealing with the request within 2 months, then make sure you agree to an extension with the employee. And that's particularly if you are offering a trial period. Because as we'll see, claims can be brought if the employer fails to deal with the request within the decision period. So it's really important that you get that agreement if you're going to extend it. Are trial periods prescribed? So nor the new legislation provide for or regulate trial periods, although there appears to be nothing to prevent the parties from agreeing those. There's no changes to that. So there's no requirement in the new legislation about trial periods. But as I've said, I think they're very good in being able to defend any claim to demonstrate that the arrangement didn't work. So if there's any doubt that the arrangement, if an employer doesn't believe the arrangement's going to work, but they can't convince the employee of that, and they're concerned about a claim, a trial period is always a good thing to do. Are there any changes to granting the request? The position remains that if the employer accepts the employee's flexible working request or the parties reach agreement on a variation of the request after discussion, the new work pattern will be a contractual variation to the employee's employment and will be permanent unless agreed otherwise later on. Employer is obliged to issue the Section 4 statement within 1 month of the date of the change. And beyond that, I would recommend that the changes are confirmed in writing. Once the working pattern has been agreed, then, as I've said, any further change needs to be confirmed in writing. Are there any changes to rejecting or refusing the request? No, it remains the same. A request can only be refused on one of the 8 permitted statutory grounds, and there they are listed. The burden of additional costs, detrimental effect on ability to meet customer demand, inability to reorganise work among existing staff, inability to recruit additional staff, detrimental impact on quality, detrimental impact on performance, insufficiency of work during the periods the employee proposes to work, or planned structural changes. You have to refer to one of those grounds if you are refusing a flexible working request. Are there any changes with regards to treating an employee's request as withdrawn? No, no changes there. So an employer will still be entitled to notify an employee that it has decided to treat the employee's conduct as a withdrawal of the employee's flexible working request, where either of the following apply. And the emphasis is highlighted. So the employee, without good reason has failed to attend both the first meeting arranged to discuss their request and then the next meeting arranged for that purpose, 2 meetings. And then the employer has allowed the employee to appeal against the rejection of their request or to make a further appeal, and the employee, without good reason, fails to attend both the first meeting arranged by the employer to discuss the appeal, and then the next meeting arranged for that purpose. Again, 2 meetings. Good reason, good reason. If somebody is sick, then that's a good reason. The employer must notify the employee of its decision to treat the conduct of the employee as a withdrawal of their application, and there is no statutory definition of what amounts to a good reason. Okay, any changes to appeals? No changes there. So it is still the case that the legislation does not expressly require an employer to allow an employee to appeal against the rejection of their flexible working request. However, the ACAS code confirms that it is good practice to do so. So because there is no legal obligation on an employer to hold an appeal, if the employer does follow the code and offers the employee an appeal, it falls within the decision period. So an appeal will have to be conducted within the 2-month decision period as well. So that doesn't fall outside of it. So 2 months is not a huge amount of time to deal with a first meeting, decision, appeal, decision, particularly when meetings are being arranged. So bear that in mind. And again, if you are offering an employee appeal, then you might need to agree an extension of the decision period in order to ensure that you don't fall foul of missing and not meeting the decision period window to make a decision in. Are there any changes to the number of times an employee can make a flexible working request? So currently an employee can only make 1 request under the statutory regime in any 12-month period, time being counted from the date on which they make their request. From the 6th of April, the current position will change so that an employee may make 2 applications to the same employer during any period of 12 months, but the employee will not be able to make a further application while another application to the same employer is already proceeding. And for those purposes, or the purposes in looking at what the word proceeding means, an application will be proceeding during any of the periods where an application or request is being considered. So the period between where the application is made and ending when the request or application is concluded. Any period beginning when an appeal against a decision to refuse the request is brought, and ending when the appeal is concluded, and any period beginning when the decision period for an application or appeal is extended, with retrospective effect, and ending when the application or appeal is concluded. And then concluded means the decision made in all of those. So it's just, the legislation is ensuring that 2 applications can't run concurrently, but they've got a whole load of definitions in there which ensure that won't be the case. So just make sure that if an employee does make another request within 12 months, so they make 2 requests within 12 months, the second request isn't being made before a decision or appeal decision is still outstanding. What if there are any procedural failings by the employer? An employee who has made an application under the statutory scheme may bring a claim on the basis that, and there's the list. So if you fail to deal with the request in a reasonable manner, if you fail to notify the employee of your decision within the decision period, if you reject a request for if you reject a request for none of the permitted grounds, or if you reject the request based on incorrect facts, or if you treat the request as withdrawn, but neither of the grounds that we've just looked at apply. So they are the procedural failings that an employee can bring a claim in relation to. So there's quite a long list, and that is why it's really important that you follow the procedure. If a claim is brought, what happens? What do the tribunals do? Well, the tribunal cannot question the commerciality of the decision. So they won't look behind the business reason put forward by the employer to support a refusal of the request. And neither can the tribunal substitute its own decision as to whether or not the request should be granted in the circumstances. So the tribunal has got quite a limited jurisdiction or remit in respect of these particular claims. The role is really restricted to reviewing the procedure, considering whether the request was taken seriously by the employer, consider whether the decision was based on correct facts, and consider whether the reason given falls within the permitted grounds. And a relevant case on this point is the case of Wilson and Financial Conduct Authority. In this case, the Employment Tribunal dismissed Miss Wilson's claim that the FCA had rejected her flexible working request on incorrect facts. So that's one of the listed grounds. Namely, that if she worked entirely from home, it would have a detrimental impact on quality and performance. Miss Wilson was a senior manager with responsibility for 14 members of staff. She started working from home shortly before the COVID-19 pandemic. Following the end of the pandemic, the FCA developed a policy which mandated 40% office attendance. The tribunal found that Miss Wilson's line manager had genuinely considered the merits of the application and that Miss Wilson's role as a senior manager was an important context. Was important context, since that in the tribunal's judgment, it fed into the rest of the performance and quality to be expected from her and her team. The line manager had taken account of Miss Wilson's strong performance to date and acknowledged that much of her work could be done remotely. However, she considered, the line manager, that working remotely would have a detrimental impact on the quality and performance of work, such as welcoming new staff, internal training and supervision, the need for a visible presence in the office to provide structured or informal advice and support to team members, as well as an in-person attendance at certain meetings and conferences. She did not pursue a compromise solution of 10% or 20% attendance because Miss Wilson had indicated that was not acceptable. So in that case, her claim failed for incorrect fact pleading. So she claimed employer rejected request based on incorrect facts, and that claim failed. So a further question is whether there are any changes to the remedies available for a successful claim. No changes there. Where a tribunal finds that a claim has been well-founded, it must make a declaration to that effect and order compensation to be paid to the employee by the employer of such amount as the tribunal considers just and equitable, up to the permitted maximum of 8 weeks' pay. And the maximum amount of compensation is 8 weeks' pay, as I've just said, but the statutory cap applies on that week's pay. So that's currently £643, and it will go up to £700 on the 6th of April. Again, going back to the case of Wilson, the employee did succeed in one element of her claim. So she didn't succeed on the element of the claim that we've just looked at, but she was awarded 1 week's pay because her employer's letter rejecting her appeal was 21 days after the end of the statutory decision period. So because the employer failed to deal with the decision and appeal within the decision period and was 21 days late, she got 1 week's pay. Are there any other claims that these employees could contemplate? Oh, yes, and that hasn't changed. So an employee could bring a claim for unlawful detriment, similar to what we've looked at, and also a claim for automatic unfair dismissal if they're dismissed by reason that they made or proposed to make a flexible working request. So those 2 claims that we looked at in respect of the carer's leave provisions also apply here. If you're treated detrimentally because you exercise your right to make a flexible working request, or if you are dismissed because of that, then you can bring a claim for automatic unfair dismissal or detrimental treatment. And if you succeed on those claims, the same compensation applies, just an equitable and also the basic award and compensatory award if automatic unfair dismissal succeeds. Any other claims? Yes. Typically, flexible working requests will be made by employees seeking to vary their working hours in accordance with childcare commitments, religious requirements perhaps, or if they're seeking adjustments because they're disabled. So as such, there are other possible claims that employers need to be aware of when dealing with these flexible working requests. As we've also seen, there's carers are predominantly women, and so in making flexible working requests, well, you see a lot of flexible working requests being made when female employees return from maternity leave. So inevitably, when employees make these kind of claims, breach of flexible working rights, they usually tag on a sex discrimination claim as well. That's disability. So this is the sex discrimination element that that employees may pursue. Direct sex discrimination occurs, as we've seen, where because of sex, the employer treats the employee less favourably than they would treat other employees. Both men and women can make flexible working requests. Some may say that employers look more favourably on requests by women than men. A practice which could expose the employer then to a claim of direct sex discrimination by men. So if a request to work flexibly is not considered seriously because it comes from a man, when the same request would have been considered seriously if it had come from a woman, then the male employee may succeed in a claim for direct sex discrimination. This happened in the case of Walkinshaw and John Martin Group, where a man who had been denied the right to work part-time following his wife's maternity leave claimed direct discrimination because women in his firm were regularly allowed to work part-time. This approach obviously only works where a man can demonstrate that a woman's request would have been granted, or at least seriously considered. So if the employer would have treated a request from both a man and a woman in the same way, then such a claim won't succeed. As we've also seen, indirect sex discrimination occurs when there's this disadvantage because of a PCP being applied to a group, and then also the disadvantage being experienced by the individual employee claimant. An example of indirect sex discrimination in respect of a request to work flexibly is given in the ACAS code, and it says, Linda has childcare responsibilities and asks to work part-time. Her employer responds by saying that her job, a solicitor, is capable of being done effectively by a part-timer. Incapable. So she says, I want to work part-time. Her employer says, no, the job can't be done part-time. Unless the employer can objectively justify that provision, i.e. the provision, the requirement to work full-time in that job, then Linda will be able to bring a claim for, a successful claim for indirect sex discrimination. We're getting on for time. Just check.
We're a little over, Keeley.
Okie dokie. Well, we're nearly at the end of this section. So I'll just finish off this section if that's okay with you, Eloise.
Yep.
If everyone's happy with that. So the other claims that we might need to be live in respect of in dealing with flexible working requests, as I've touched on before, are disability discrimination. So when dealing with flexible working requests, we need to be wary of the requirement to make reasonable adjustments in respect of a disabled employee, and also in respect and considering if the dependent or if the employee is caring for a dependent. But if it's the employee that has the disability and is making a flexible working request, because they feel they need reasonable adjustments to be made to ensure that they are not placed at a disadvantage because of their disability, then we need to make sure that we consider and implement any reasonable adjustments. And if we don't, then obviously that could lead to a successful claim of disability discrimination. Also, as I've touched on, religion or belief discrimination. An employee may make a request for flexible working to change days on which they work or their hours in order to accommodate their religious beliefs and requirements, and a rejection of that flexible working request could result in an indirect religion or belief discrimination claim. And then lastly, the age discrimination point. A further risk for that, if, for example, a request is to work from home and the employer has a practice of only permitting such requests from older, more senior employees and rejecting requests from junior employees who tend to be younger, just be live to a potential indirect age discrimination because of that particular practice. If you fail to deal with a flexible working request in a reasonable manner, not only could you be in breach of the legislative requirements under the flexible working procedure, but you could also face a claim for constructive dismissal by an employee, by them asserting that an employer's failure to deal with a flexible working request reasonably impacts on the trust and confidence in the employment relationship, entitling the employee to resign and bring a claim for constructive unfair dismissal. So again, be live to dealing with these requests in a reasonable way, because it could result in an employee resigning and bringing that particular claim. What actions do we need to take now? Again, we need to ensure that we update existing policies to take account of the new rules, and to train managers on that who are dealing with their teams and any requests that might come to them from team members. And that concludes the two rights that I wanted to touch on today. There is a section at the end of the slides, which I'll send to you, Eloise, about the paternity leave rights, but we did discuss those in the previous huddle. but they're there, and if anyone's got any questions about them, then obviously let me know.
Brilliant. Thank you, Keeley. Do you mind just turning off your slides?
Yes.
Fab. Great. Nice to see your face again. Thank you so much for today. Really informative as ever. So if anybody's got any questions, feel free to contact myself or contact Keeley directly. I'll send out the slides and the video over the next week. So just bear with us. We'll just edit a few parts of it. But thank you very much for joining us. If there's anything that you would like us to talk about on the huddle, any topics you want us to cover, then again, feel free to pick up the phone or email me and I'll be happy to organise. So lovely to see so many people and look forward to speaking to you soon. Take care. Bye.